Hello again, everybody. Back again here to relay to everybody as promised my most recent correspondence I received from the Ohio Supreme Court's Office of Disciplinary Counsel in relation to the alleged misconduct by Alex Savakis in Trumbull County Eastern District Court in the matter of the resolution to the abuse against my son, Stephen. This little guy. Remember him? Yeah. Because that's what, I mean, this little guy, that's the one it's all about. Okay, so all these words on these pieces of paper, as far as I'm concerned, mean absolutely nothing other than the fact that this is going to get us where we need to be. So, I will read to you the most recent correspondence letter I received, and you, of course, can make your own determination as to what the intent here is. Mr. Hallett, in response to your complaint against Magistrate Alex Jerry Savakis, file number as I have read before, after consideration of your most recent correspondence, we have determined that further investigation of your complaint against Magistrate Savakis is not warranted. Like I'm supposed to be surprised by this, right? Notwithstanding your belief to the contrary, we have evaluated the issues raised in your complaint. Our evaluation of the items alleged in your letter indicates that you're raising issues that were previously reviewed. I read that letter to you, and I discussed no previous issues. I discussed the current issue, which is Magistrate Savakis, to which, as I said at that time, being that they repeated the exact same language in their response that was in the complaint, only proved to me further that they didn't even read the complaint. Anyway, the opinion of disciplinary counsel remains that there is not substantial credible evidence of misconduct by Magistrate Savakis, and that you have legal process available to you to redress your concerns. And she goes on to further add that there is some bar regulation for section 4, or yeah, 4 section, subsection I, subsection 5 provides that no further review of the appeal decision by disciplinary counsel dismiss complaint, blah, 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 blah. And and at the end she says, in parentheses, emphasis added. So if that's not a clear language of telling me to go pound salt with emphasis added, I don't know what is, because I've read that piece of legislation, by the way. And, it's amazing to me that uh, government seems to know they only know one thing, what they don't have to do. Okay? But here it is in plain language in their first correspondence to me on this very same issue with Mr. Savakis. Now, this is their words, not mine, according to their mission statement and what their responsibilities are. Please be advised that the authority of disciplinary counsel is limited to investigating alleged misconduct. Hence the key word here being investigating. I have yet to see any evidence of any investigation, other than them to tell me that they investigated what they didn't have to do. But anyway, and they go on to describe these alleged misconduct and violations of the Code of Professional Responsibility and the Ohio Rules of Professional Conduct and the Code of Judicial Conduct by attorneys and judges. Now, I have no idea what this alleged code is because I can't find it anywhere. It doesn't exist, at least not for my review. So, what exactly is it you're talking about? Because letter number 2 contradicts the very first opening statement of letter number 1. So, again, I'm going to say that's nothing more than the same political doublespeak that I've become quite accustomed to with dealing with the state of Ohio. And the rest of you should not be surprised because that's just government. As my dad says, you're watching wrestling, so, don't expect any kind of, unless you draw them a map, you're not getting any farther than over the threshold of the door, so don't let anybody kid you. Professional standards of practice and ethics notwithstanding, those went bye-bye a long time ago, and we talked about that. So, here's where we are. Fortunately for me, under the UCCJEA, which is the federal standard by which we govern everything from jurisdiction to child support and everything in between when it comes to matters of children. So under section 63-15-336A, I do have, I've reached probable cause to establish a need to file for temporary jurisdiction here in the state of Florida as to the fact that the state of Ohio is even unwilling to discuss the issue. They don't even want to hear about it. The fact that I have a doctor, a PhD expert witness, is irrelevant to them. They want to keep things spinning just as they are so they can keep collecting money. Now, again, we talked about that. So, again, under the UCCJEA, which I just recently found, the fact that the respondent in this case has pre-existing issues here is, is relevant to the issue. Because you can't make a decision in this issue until you make a decision in that issue. Why? Because that is what federal law says. And this piece of legislation is written under the basis of federal law. Now, the fact that as of June 10, 2013, respondent in this case owes child support arrearages totaling $76,377.33, which, by the way, is public record, so not subject for liable there. But that is true, and I have that document that proves that. So anyway, the fact that she fled, I mean, it's obvious that she fled Florida to escape prosecution for that, and is in violation of federal law, not even state law of Florida or state law of Ohio. That's federal law. That's D.C. The big Capitol building in the White House. Everybody keeps jumping the fence. Yeah, that guy. That's who wrote that piece of legislation. So, well, Obama didn't write that, but that's D.C. is where that comes from. So anyway, being that we have met the 63-15-336A burden of probable cause for emergency temporary jurisdictional transfer under abuse being of not just Stephen in this case, but with me as well. I'm sure you've seen the video. What the kids thought the last time I was up there, when I lived up there. So based on that, that is a proof of physical abuse against me. The doublespeak from the Ohio Office of Disciplinary Counsel, these guys, that's proof of judicial and governmental abuse and bullying. Call it whatever you want, whatever the current buzzword is. I haven't checked today's hashtag, so I don't know what that is. But anyway, just those three things alone, that's, 1, 2, strike 1, strike 2, strike 3, you're gone. So, that being said, I go to court, and I'm working on preparing the necessary documentation under UCCJEA for emergency transfer jurisdiction here to Ocala, Florida. So, now that we've met the burden of proof for that, the burden of responsibility governing proper established judicial procedure, ethics, professional standards of practice, and all of that other fun stuff that we've talked about, going up to file these appropriate motions, and the respondent will be receiving appropriate notice in the mail or via process server, whichever procedure requires that I follow. So, as developments happen, I will keep everybody up to date. So keep liking, keep sharing, keep following us on Twitter. Remember that the end goal here is this little guy. He is the reason we're doing this. Okay? This little guy right here. There is no other reason, despite what you may be hearing from her or whoever up there. I can tell you, I'm the guy filing the paperwork, and my intention is Stephen. Always has been, always will be. So, that being said, I will say farewell for this particular video. Hope everybody has a wonderful evening, and we'll see you soon.